do more questions and answers at the end.
Okay.
But we're going to keep on track here. Now, right now we're on the cartoon, 2 pages after number 9. In other words, right before number 10, it says you can lose your lien rights. And I have 2 cartoons here that I just thought were kind of funny. You got these 2 nails, and then I heard a loud bang, and when I turned my back, he was gone. And then you got the other one where you got the Godzilla eating the contracts at the office, and I think I can feel pretty secure that these contracts won't be binding. In other words, like I was saying before, change orders, get them in writing if you can. If not, it's going to be pretty tough to enforce. I just want to talk to you now about owner defenses. So now you filed your claim of lien, you've done everything properly. What type of defenses can an owner raise to the enforcement of your claim of lien? Well, I've had this happen. I went ahead, filed a claim of lien on behalf of a client. The next thing you know, the owner is producing to me a final release of lien signed by my client. I called up the client and I reamed him. I said, why in the world have you paid me all of this money when you signed a final release of lien? You released your lien rights. Why? I don't even understand. So the owner says, hold on, let me look in. Oh, excuse me, the client contractor of mine says, hold on, let me find out. Well, come to find out, it was one of his employees who came to pick up a check, didn't even know what they were signing, and we had to make some real inventive arguments. How I got my client paid is beyond me. I still got him paid. I'd like to go back and look at how I did it, but I mean, it was real bluffing is what it wound up coming down to. I remember that, and because I basically accused the owner of fraud. That's what it was, of slipping it in there.
Officer of the corporation or something to actually legally sign for a release.
Well, that's what we argued. That look, this person had no authority. You knew that they had no authority. This person was just a delivery person,
Right.
and just picking up a check. And they thought that they were just signing that they were picking up a check, and this isn't going to release all lien. You knew that we were still doing work. There's things to that effect, but I don't want to be in that position, man. I got to tell you, it ain't good when I see that final release of lien coming in for when I'm liening. I ain't happy about that. So make sure if you are going to be giving releases of liens, make sure it's a conditional release of lien. I know that I have it on my website. I know that Sunshine Notices has it in their packet. Use that conditional release of lien. So let's assume that the GC says, I'm not going to pay you unless you give me a release of lien because I need to give that to the owner to show in order to get my payment. Well, you can give a conditional release of lien. A conditional release of lien says this. It'll have a specific clause in there that says that this release is contingent upon me being paid, and that these funds are actually good. In other words, let's assume that you get a check for your conditional release of lien, or you get a promise that you will be paid. You're only giving a conditional release of lien, which becomes effective once you get paid. The other thing that an owner can do, this isn't really a defense, but this is something that an owner can do to get the lien off the property, and this is called a transfer bond. Let's assume that there's a $100,000 lien on the property. The owner wants to do something with the property and needs that lien to be taken off the property. So they go to you and they say, take it off. You say, no. Okay. Owner says, no, I don't think you're entitled to it. What can the owner do? The owner can bond off the lien by posting cash or by contacting what's called a surety company, an insurance company, which will take a certain percentage, and they'll bond off the lien. How does that work? The owner has to post 100% of whatever you lien, plus 3 years worth of interest, plus it's some calculation for the attorney's fees, but it's usually, because the amount's usually pretty high, it's usually 25% of whatever the lien amount is. So in this case, it would be $100,000 plus $25,000 for the attorney's fees, anticipated that would be incurred, plus 3 years worth of interest, because in case the case takes about 3 years. Who knows, maybe you have a case that goes into appeals, whatever else. So what if the amount that's posted is not enough? The 713.24 allows you to go back before the court as many times as you want and request that court to increase the amount. What happens if the owner doesn't have any more money to post and they've already bonded off the lien? You may have a problem. Or the judge may be free to put the lien right back on the property. But what happens happens if that owner has already stripped out all the equity out of that property? You may have a problem. I'm not saying it's perfect, but I'm just saying that's something that an owner can do. Or what I've also done is I've also had a judge allow me to do discovery. I don't want to be in this position. It's ridiculous. It's almost like I got to collect before I even won the case. But then I got to do discovery to find out what other assets this owner has, so that I can put liens on everything that that person owns, to make sure that I get paid in case we win. The other thing is that requiring a contractor to furnish a statutory payment bond. Again, this isn't really a defense. It's just it's a way that the owner can look towards something else to make sure that everybody gets paid. Here are documents that I just want to make sure that you look out for. When I represent an owner, these are the 3 documents that I send out first. Before I even know anything about the case, this is what I'm sending out. They're pre-printed letters, basically. They're just copied from the statutes. They're found within 713.16 for the most part, and 713.165, and they go both ways. As a contractor, you can serve these requests for sworn statements, and as an owner, you can serve these requests for sworn statements. And there are 3 different types. You can ask for a list of all the subcontractors and suppliers. You can ask for a copy of the contract, and you can ask for sworn statements of account that swear to, hey, this is how much has been spent, this is how much has been received, this is what's uncompleted, and this is what's left to be completed. Whatever it is, there are a bunch of things that have to be completed in there. Now, the ramifications for not responding within the time frames, which are either 30 or 10, depending upon what document we're referring to, are that either the person who's liening may lose their attorney's fees, their right to attorney's fees, or may lose their lien rights entirely. So you got to pay attention if you receive these, because they'll have a big warning. They'll say exactly what the ramifications are. I don't remember what they are off the top of my head, but look for it. If you see one of those documents that requests a sworn statement of account, pay attention to it and respond back and make sure that it's sworn. Okay? And the only thing I'm trying to do is I'm just trying to give the contractor a problem. I've had it where they've come back and they were not timely. And I was arguing, hey, maybe this contractor shouldn't be entitled to their lien rights anymore. Or maybe they didn't answer it completely properly. So again, I'm making that argument that maybe this contractor has some problems enforcing their lien rights. Next page, owner defenses again. We spoke about before how when you're liening for things, it has to be in accordance with your direct contract. Well, that's again a defense. If the work performed by the liener is not within the scope of the direct contract, it's not lienable. Next one, where owner has made all the proper payments. What do I mean by that? Remember when I was giving you the example